My name is John C. Brittain. I am a law professor and a civil rights lawyer. I grew up in Norwalk, Connecticut, the southern part of Connecticut, about an hour's drive from New York City. I was born and raised in the Norwalk area. Before I was born, my family, like others, migrated from the north to the south. However, their journey was quite unusual. My mother was the maid and the cook and the nanny, and my father was the butler and the chauffeur and the captain of a small Chris Craft yacht and the pilot for a small Piper Cub airplane. They worked for Candler Dobbs, the chairman of the board and the CEO of the Coca-Cola Bottling Company. In the mid-30s, Coca-Cola decided to join the New York Stock Exchange and move their chief executive officers from Atlanta, Georgia, to New York City. My parents lived in one of those luxurious, like Avenue of America's or Fifth Avenue apartments for about a year or more. But the Dobbs family didn't like living in New York City. So they moved to a suburban from New York City location in a little place called Westport, Connecticut, right next to Norwalk, Connecticut, where I would grow up. I can remember vaguely living on this huge mansion overlooking the overlooking the Long Island Sound, with about 5-car garage, including the limousine and a number of old antique cars. And I have still plenty of photos to remind me. And we lived over the garage in what would be a very satisfactory apartment with all of the current updated kitchen and bathroom and living room and dining room, which would be the servants' quarters for the mansion. Dobbs lost his fortune due to alcoholism and divorce, and we moved from Westport, or Saugatuck, Connecticut, to the working class factory town then of Norwalk, Connecticut. And the Dobbs family gave my parents a second down payment mortgage on a home which they selected for my parents. And as I tell the story now, they were Caucasians, and they selected a nice working class home in the northern part of Norwalk, which was virtually all white. As a result, I walked nearly a mile to elementary school with 4 other boys that were my best friends and playmates, and I was the only black student in elementary school from 1st grade to 6th grade. By the time I went to high school, it was fully integrated with other parts of Norwalk High School. The unique experience I had in high school is that I was the captain and the high scorer for the Norwalk High School hockey team. The hockey team played all over parts of New England, Massachusetts, New Hampshire. Maybe once we went up to Vermont. And we played over in upstate New York. I was the only high school African-American hockey player in 1962 when I graduated from Norwalk High School in all of New England and New York, and they used to jokingly say, as far as one could see west to North Dakota. Norwalk is located on what is called the Long Island Sound, large body of water between Connecticut and Long Island, New York, and all the way into Manhattan, New York. And I grew up where the town had a beach called Calf Pasture Beach. And that was the major hangout for all people in Norwalk. the beach in the summer and just hanging out in the parking lot along the water in the winter. And next to it were a number of boat basins where boating was a big recreational sport. And it was also a part-time job in the spring, before boats were made of fiberglass, to sand boats down to take off the varnish and smooth out the wood and bring it back up with stain and with polyurethane to make it gloss and protected. And I grew up around the water, taking a little skiff out. That's a little boat with a sail, or a little skiff with a horsepower motor, no more than 10, 15 horsepower. And we just run all up and down the harbor and along the little river there. And that's how I learned to be a sailor. Yes, I experienced racial segregation in Knoll, Connecticut in the 1950s, early 1960s. I experienced it, for an example, in my neighborhood and at the school, where, as I said, I was the only black elementary school student. However, I grew up in a neighborhood with a recently immigrated Israeli, and I knew all the Jewish customs, and we played all the time. I also grew up with another friend in my backyard who was an Italian by ancestry, and just up above him was an English. So if anyone ever called one of us, which we called ourselves the Four Musketeers, after a famous movie, where we were one for all and all for one. So if someone called me the N-word, or someone called the Jewish person the K-word, someone called the Italian person the G-word, or someone called the English person, which I didn't even know that epithet till I met him, the L-word, the fight was on. I went to Howard University in a rather unusual way. As I entered my last year in high school, and I was a, quote, star hockey player, at least I was a high scorer and the captain of the team, I was on a educational counseling trek to go to a small liberal arts college throughout New England or New York and to play hockey. My sister came home where she was 8 years older than I. She had started at Spelman, graduated from Howard University here in Washington, D.C., and had a master's degree in social work. And she was certainly my sister, but she was like my young aunt. And she came home around this time, going on November, and applying for college. And my mother and father and I laid out the plans with our high school counselor that I was on a track to go to a small liberal arts college and play ice hockey. And she put the hammer down and said, "Oh, no, he won't. He's going to an HBCU school to learn to live with his people," after growing up here in Norwalk, which was predominantly white. And I want him to go to Howard. I applied to Howard. I was accepted. I went to Howard. I never thought again about playing hockey, particularly after I played around with all those young, pretty black girls in my first year of college, sitting on the wall down by the quad where the women's dormitories were located. I went to Howard University undergraduate school from 1962 to 1966. That was a period of time with a tremendous amount of protest and agitation in the district, with a movement against the war in Vietnam, with the civil rights movement going on in the South, and all the way up south too, as I call, above the Mason-Dixon line, or the Potomac River, in Cambridge, for an example, Maryland. And I was in school with Stokely Carmichael and Rat Brown when he was around in town, and with Marion Barry, who was the head of SNCC in Washington, D.C. in the early 1960s. And with John Lewis, another head of the SNCC, and of course, longstanding congressperson from Atlanta, Georgia. So I was swept up in the movement, and there was often a question of whether at least of those who were agitators would quit school and go to the South and join in the civil rights movement, or those who would stay, primarily because we didn't want to risk losing our deferment from the draft into the war and probably go to the war in Vietnam in the Army, and stay in school and keep our deferment to avoid the draft. So I decided to stay in school, but I made a pledge that when I finished school, I would then do something to support civil rights. During that time, and being in the, quote, student movement, I met a law professor at Howard who would later become my mentor, and his name was Herbert O. Reed. And Professor Reed was one of the lawyers, along with the president of Howard University, then James Meredith, that were the lead lawyers in one of the 5 cases in Brown. Most people just think about Brown in Topeka, Kansas, but there were 5 cases decided by the Supreme Court, one from South Carolina, one from Virginia, one from Delaware, certainly one from Topeka, Kansas, but the 5th one was from Washington, D.C., called Bowling versus Sharp. And my professor was one of the lawyers in that. He also represented many of the student agitators who had protested at Howard. Some of them were terminated from school. He represented them, and they were my buddies, so I got to know him. When I graduated from Howard University in 1966, I was dead set that I wasn't going to go to the war in Vietnam. And I came in touch with Muhammad Ali when he came on campus, or he said something in public, and in one of his famous color-coded rhymes, which made clear sense, he said, "No black man should fight a war started by a white man to kill the yellow man who hadn't done anything to the black man. And if blacks were going to fight against anybody, they should fight against the man who lynched them." And he would let the saying drop and let you figure out who he meant. But he meant if black men were going to fight anybody, they should fight white men. So when I graduated, my deferment expired. However, they had another rule, and by that time, I was as experienced in the Selective Service Code, that was the set of regulations that governed the mandatory draft, called mandatory conscription, to go into mainly the Army and probably fight in the war in Vietnam. So I knew that there was another deferment if you went to graduate school. You could have a deferment for 3 out of the next 5 years. So I went to graduate school first with applying to the Howard University School of Religion, not to study religion, but my major was political science with a strong minor in philosophy. So I was going to go to graduate school to study philosophy, but Professor Reed said, if you're going to waste your time going to graduate school, I didn't have necessarily any intent of earning the degree. I just wanted to get a deferment for another year because the prediction was President Lyndon Baines Johnson couldn't maintain that war in Vietnam after the big Tet Offensive around 1966-67. So he said if I was going to waste my time, I might as well come over to the law school and waste my time over there, and maybe I would decide to go to and finish law school and earn a JD degree. So that's how I really went to law school to dodge the war in Vietnam. Yes, I meant to say James Naybert. James Meredith, who was on my mind because I've been doing some work in that area, was the first African American to integrate a major Southern university, the University of Mississippi, in 1962. Yes, but I'm talking about President James Naybert and Professor Herbert O. Reed were 2 of the senior counsel, along with Thurgood Marshall, in the Washington, D.C. school desegregation case. Continuing to dodge the draft, even after I graduated from law school, I came up with a plan. As I said, I became an expert in the Selective Service System and its set of regulations, like a certified public accountant. knows the Internal Revenue Service code. And they had a deferment for school teachers and for firefighters and police officers under a certain provision that it was in the nation's health, safety, and interest not to draft them. I was fortunate to win a fellowship for a neighborhood legal services program called the Reginald Heber Smith Fellowship Program that would take lawyers and look systematically at some of the causes of poverty and inequality and come up with any public policy advocacy or any major litigation that could challenge it, like Brown versus Board of Education, challenge segregation. And in addition, I was able to win a job with, again, President Johnson's Neighborhood Legal Services Program in Oxford, Mississippi, at North Mississippi Rural Legal Services. I took that package together and I applied under this provision of the draft in the nation's health, safety, and interests, and I asked my all-white draft board in my northern Norwalk, Connecticut, if they would give me the same kind of deferment for teachers and firefighters and police officers if I went to Mississippi and I helped the black people gain civil rights. And they granted it to me. And 55 years later, I'm still surprised. In 1969, I went to Oxford, Mississippi, the home of the University of Mississippi, or known by its nickname as Ole Miss. This was 7 years after James Meredith integrated Ole Miss. James Meredith integrated Ole Miss as the first African American throughout all of the South who was admitted to a white state university that practiced de jure segregation. It took a court order, 20,000 National Guard and other soldiers, hundreds and hundreds of U.S. Marshals to escort James Meredith into Ole Miss. There were widespread and violent protests by white supremacists, including students, and 2 or 3 people died while rioting and threatening soldiers and officers with violence. I went to that place to begin my civil rights practice as a poverty and civil rights lawyer with the North Mississippi Rural Legal Services. I filed the first school desegregation case in Oxford, Mississippi, the home of Ole Miss, and the surrounding county, which they call Lafayette, although most people would pronounce it Lafayette, as in French. And it was the first time that these schools were integrated by court order. And soon after we won that case, a group of students from the University of Mississippi, all black, engaged in a peaceful, nonviolent protest to underscore the racism and the segregation which still existed on campus, although blacks were admitted to the college by then. In one particular incident, there was an international entertainment group that performed and danced and sang that was performing at the university called Up With People. And it promoted tolerance, and it promoted understanding, and it promoted togetherness. About 6 black students walked on that stage, raised their clenched fist, and walked off in silent protest. By the time they reached the door, hundreds of local law enforcement, state police, local police, sheriffs, deputy sheriffs had gathered and arrested the people in the auditorium. They went on throughout the whole campus and arrested any black that they could find. 90 people were arrested, and they took them to the worst, most dangerous, and later declared unconstitutional prison farm in Mississippi called Parchman Prison. Parchman Prison, in which I later participated in litigation to declare it unconstitutional and to reform it, prisoners were given rifles and the authority to guard other prisoners and to shoot them, resulting in death in many instances. If the prison guard thought they weren't obeying the rules. And so they were called trustees, armed with rifles, guarding other fellow prisoners. And if they shot and killed someone, there was no law enforcement investigation. They were immune from any criminal prosecution. The federal courts later declared this prison cruel and unusual and a violation of the Eighth Amendment. But back to the campus, I helped bail those students out of the prison, and the local prosecutor brought misdemeanor charges against all of the students for breach of peace. That was the same statute they used to enforce segregation when demonstrators engaged in nonviolent, peaceful sit-ins and refused to leave. I clogged up the local courts by filing demands for a jury trial, and it stopped all of the proceedings in the municipal court, much to the displeasure of the judge and to the prosecution and to all the lawyers with civil cases in the courts. So the prosecutor dismissed the charges, and they reached an agreement with the University of Mississippi that the university would bring due process hearings against all these students. So I clogged that up too in representing still all the students, and I filed a request for a hearing for every student. That clogged up the university, and we made an agreement with the students' permission that they would drop all the charges against 8 of them whom they had photos of, and they were also the leaders. And so they became a famous due process case called the Ole Miss Eight. And they were all found liable for their actions. They were all dismissed from the university. And that was like 2 strikes against me. And the 3rd strike would come up later before something bad happened to me. I was ultimately arrested, charged with practicing law without a license, a felony that, if found guilty, would result in imprisonment for up to 5 to 10 years and complete disbarment as a lawyer. The incident that led to the charges in the case involved my representation of a minor in a juvenile court before a judge. I was a licensed lawyer after passing the bar in my home state of Connecticut. The local rules allowed a lawyer who was licensed to practice in an out-of-state bar could also appear in court in Mississippi if they engaged in full-time practice in the state for a nonprofit organization that didn't charge any fee, and further if they appeared in court with a Mississippi lawyer who was licensed in Mississippi, and they requested the court in a judicial pleading called permission to appear pro hoc vice, or for this particular case. And the judge signed an order approving me to appear. The juvenile we represented was charged with a minor offense of making obscene phone calls to a victim. In those days, the telephone company was called Ma Bell, and the prosecution brought up an expert witness from the Ma Bell telephone company to testify how they traced the obscene phone call to the home of my client and his family. And they had a system where if the victim received an obscene phone call, the victim could hang up and immediately call a certain number. That certain number would trigger a machine with the phone company that would print out the number that had immediately called that home before the obscene phone call. And they traced that number to the home of my client. When the expert witness from the phone company explained how they identified my client, I was the lawyer who cross-examined the witness. I set the witness up by going through all of that procedure. And I asked him, "Are you sure you're correct?" And he said, "Yes." And then I asked him the punchline. "Did you know that that was a party line?" Well, when I tell that story today, many people don't know what a party line was, but it was a multi-party on the line. In those days, you called an operator. It wasn't even automated like when you had a little dial that you make the number and it rolled back and you completed the phone number, but it was telephone operators, all women by the way, and they would take out one cord and put it in another slot and take out another cord. That's how you connect the cord. And sometimes if you're ever on a party line, and I once was, you would pick up the phone and you would say, "How long are you going to be on this party line? You've been on it for 30 minutes and I need to make a phone call." And when you meant to make a phone call, you would pick up the phone and you knew the operators and you would say, "Jane, give me 4329. So in any event, he admitted he didn't know that it was a party line. I then established it was a party line. The case was over. The judge had to dismiss the case because they couldn't prove by a preponderance of the law that and evidence that the phone call came from my client's home because the other home on the line also had small children who also home at the same time. That, I think, was the straw that broke the camel's back. One day, the sheriff summoned me to come to the jail. Lawyers could bail a client out of jail just on an appearance bond, with the lawyer asserting and attesting that the client is likely to return to court when the case comes up. And it was all a ruse. And the sheriff even apologized to me that "I hate to do this to you, John, but you are under arrest for practicing law without a license, a felony offense," and he put me in jail. My legal director and my supervisor agreed to represent me, and he bailed me out, and he brought a lawsuit against the state of Mississippi in federal court under a certain civil rights statute, which said that the prosecution was brought in bad faith and retaliation against me for providing free legal services to people in Mississippi, and particularly in those three cases I mentioned to you. And we want an injunction or an order that stopped the state from prosecuting me in criminal court. My mentor that I mentioned, Professor Herbert O. Reed, was a disciple or a student of Charles Hamilton Houston. Charles Hamilton Houston was a famous lawyer in the 1930s, 40s, and up to 50s when he died. And he was the father of the theory that de jure segregation, particularly in schools, is unconstitutional and a violation of the 14th Amendment Equal Protection Clause. And Charles Hamilton Houston trained Thurgood Marshall, and he trained my mentor, Herbert O. Reed. And Herbert O. Reed trained me. So I considered myself a third generation of Charles Hamilton Houston. I spent 4 years in Mississippi as a civil rights lawyer, litigating mainly civil rights cases, civil and criminal, like Thurgood Marshall did. I then went to California, where I entered private practice. I said to myself at that time that since the United States was based upon capitalism and the private practice of law for a fee is a form of business, I wanted to try my hand at capitalism. So I went out there to practice law, and I joined up with a law graduate colleague of mine, and we created a small law firm. He was white and Irish. I was black. So we created what was called the Salt and Pepper Law Firm. And my mentor professor kept nagging at me that he wanted me to become a law professor like he and like Charles Hamilton Houston. So finally I gave in, and I went on the market for a teacher, and it was just coincidental that my home state of Connecticut and the University of Connecticut Law School hired me and I became the first black tenured professor at the University of Connecticut by 1981.
And to UDC.
After being a professor at the University of Connecticut for 22 years and being involved in a big lawsuit in the state of Connecticut as one of the lead lawyers called Chef versus ONeill that was to Connecticut and beyond what Brown versus Board of Education was to the nation. And we won a school desegregation case on very unique grounds. And by that time, I was thinking about making a change after we implemented the remedy. I was asked to come to the Thurgood Marshall School of Law, a historically black college and university in Houston, Texas, as a visiting professor. I went to TSU by its acronym for the year 1998-99. I came back to UConn to continue there indefinitely when I applied to Texas Southern and they selected me to be a dean. That's how I went to be the dean of the Thurgood Marshall School of Law. But I thought it was so honorable that I would go and be a dean of a law school named after one of my, what I call, intellectual mentors. I never had him as an actual mentor, but I followed in his footsteps in terms of civil rights practice. And in 2005, after being at the Texas Southern University for approximately 7 or 8 years, the Lawyers Committee for Civil Rights under Law, a national civil rights legal organization started by John F. Kennedy in 1965, when he summoned lawyers, some of them managing lawyers for some of the largest law firms, and he asked, and I quote, "Where are the lawyers?" Question mark. And what he meant, where were the lawyers in large firms who would be willing to take pro bono cases and represent civil rights workers? I had gone to work for that organization in Mississippi 2 years after I left the North Mississippi Rural Legal Services. The Lawyers Committee was located in Jackson, Mississippi, and I worked for them for 2 years during my 4 years in Mississippi, bringing civil rights cases, but with far more resources and far more complex cases. Unbeknown to me at that time, 30 years later, I would return to the Lawyers Committee in 2005 to become the chief counsel and the senior deputy director. And I litigated cases all over the United States and up to the Supreme Court, including one of my biggest cases with a large pro bono law firm where we represented tens of thousands of evacuees from Hurricane Katrina in Louisiana, and particularly in New Orleans. And we kept them in temporary housing, sometimes hotels, sometimes apartment buildings, for many months into 2006. And after 4 years as the chief counsel for the Lawyers Committee, I decided to go back into academia, and that's where I joined the faculty at the University of District of Columbia School of Law. Several years later, North Carolina Central University invited me there to be their Charles Houston Distinguished Visiting Professor for a year. Mark Zuckerberg, the chairman and owner of Facebook, said that he's going to allow paid advertisements using all false information, such as advertisements by the Republican National Committee on behalf of President Donald Trump. And the civil rights community, including being led by the Lawyers Committee, has protested that practice because they said that it could lead to false information about voting. Indeed, Zuckerberg wrote an op-ed in which he invoked the freedom of speech and the freedom for rights, citing Dr. Martin Luther King in the civil rights movement of the 1960s. And the civil rights community responded through Sherilyn Ifill, the director counsel of the NAACP Legal Defense Fund, the same organization that Thurgood Marshall was the chief counsel, and they said, no, don't be invoking civil rights for these fake news messages on Facebook. And they gave the example that if the fake news said that the voting day would be on one day, but it was false, and people would be misled to miss it when it was truly on another day, or when they would say false information about registering to vote and voting, and particularly where polling places would be located, but there would be no polling place there, or false information about registration, it would deprive, particularly black people, the fundamental right to vote. And they took Zuckerberg to task for the harm that became done by allowing patently false postings and messages, particularly when the sender was paying millions of dollars to Facebook. And that's what we deem a civil rights problem today with social media. I was one of 4 lawyers who once practiced in Mississippi. And we organized a book with dozens of writers, most of whom were lawyers. Some weren't, but they were involved with the lawyers. And the book is called Voices of Civil Rights Lawyers, Reflections from the Deep South, 1964 to 1980. And after organizing all of these writers, all 4 of us wrote chapters in the book. I wrote about 3 parts. I wrote, first of all, where I was raised and why I went to Mississippi, most of which you heard in this interview. I also wrote about several of my big cases, one of which you've heard in this, but that case took place in Connecticut. But I have another case that I'll tell you about that took place in Mississippi. And lastly, I wrote about the story you heard when I first started practicing in Mississippi in 1969 at Oxford, Mississippi. The book, entitled The Children in E4, written by Susan Eaton, a close colleague of mine, is the story about the landmark case called Sheff versus ONeill in Connecticut. The Sheff versus ONeill case was decided by the state court, not the normal federal court, because the federal court had established rules that made it very difficult to succeed in bringing a school desegregation case in the federal courts. One of those rules is that you had to prove in the post-de jure era suit era days, where there was just as much segregation, if not more, in particularly school districts outside of the South, which we jokingly call up South because they were just as segregated. But you had to prove where there was de facto segregation, not any law or any so-called intent about the assignment, where schools were located in neighborhoods. The neighborhoods were segregated in housing. Housing is the #1 cause of school segregation. And school districts just drove boundary lines geographically around the neighborhoods to place schools and assign students. And you had a hard time showing that that was intent. But the Sheff versus ONeill case, decided by the Connecticut Supreme Court in 1996, decided the case on a de facto, that the state was responsible for the segregation itself, rather they or anyone else caused it. In addition, the Sheff versus ONeill case was the first such case to find that the arrangement of schools by school districts, often with school boundary lines separating larger urban areas that were often poor and non-white and performing below the state's educational standards, were surrounded by more affluent and predominantly white and suburban and performing at or above the state standards. And the court held that this district boundary line was the cause of the unequal segregation and unequal educational opportunities. And they said that the district boundary line was therefore the source of the problem. And it led to the court approving a remedy of inter-district schools, where schools are matched up between urban and suburban, and students are allowed to transfer from urban to suburban, or in some cases, from suburban into the urban, where the urban school has become a magnet and has attracted a diverse group of students, both racially and ethnically, language-wise, and in addition, economically, in social and economic status groupings, and performing at above standards. And therefore, it has become a landmark case, both in the findings of the court as well as in the remedy, to promote equal educational opportunities. And Susan Eaton wrote a book about that story, which features I and many other persons, but that's where my association becomes with the book. I am now writing my own book in my 50th year of the practice of law, from 1969 to 2019, about my 50-year pursuit for educational equity in both my teaching and my scholarship, my public policy advocacy, and my litigation. I've been a competitive runner for about the past 40 years in the U.S. track and field, masters, and local races and national championships. I've been running since I turned 30 or 31 in the mid-1970s, having been born in 1944. And I have run with track clubs and run with coaches, and I've run many races in the age groups, and races are judged in winning on your age group, most by 5-year age groups, from the 0 to the 4 age, and from the 4 to the 9 age. And I'm very fortunate to have won national championships, or first, second, and third, in 90% of all of my races, because I train under a coach, and I train hard, and that's what led to my success. This past summer, I ran on a men's 75 to 79, 4 by 100 meters relay race at the U.S. Track and Field National Championships in Ames, Iowa, at Iowa State University, and we won the gold medal, and we also set a record. I'm very humble, very fortunate to have won a number of awards in the law, in social justice, in community support throughout my 50 years. And I'm most proud of the Ming Award. The Ming Award was given to me by the NAACP in their annual award as the most outstanding lawyer who has served the NAACP and without a fee. And Robert Ming was an unsung hero among the nearly dozen lawyers in the 5 Brown versus the various states desegregation case. And he was a tremendous thinker, and he was a writer that helped all the lawyers in the courts with their brief. He was a University of Chicago law professor, and the NAACP created this Ming Award in honor of him for others, lawyers who've contributed to civil rights. In terms of my leadership, I've been the president of the National Lawyers Guild. The National Lawyers Guild is one of the most progressive associations of not only lawyers, but legal workers and jailhouse lawyers. And it grew out of the Roosevelt president era of the New Deal in promoting the rights of workers and the rights for civil rights and civil liberties, the rights for immigrants, and has served the liberation movement abroad, such as the movement for majority black rule and the abolishment of apartheid in South Africa. And we have done work for Nelson Mandela in the African National Congress. The same is true throughout Africa and the Caribbean and other parts of the world. The game liberation and sovereignty and rule for their people and their kind from European imperialism and colonialism. I've also been very active in the past in the National Conference of Black Lawyers. The National Conference of Black Lawyers grew out of many black lawyers separating from then the National Bar Association, the leading black organization for black lawyers, although it's open to white lawyers too. And they created this more militant group of lawyers during the civil rights movement in 1968 after the assassination of Dr. Martin Luther King. And I was active in the National Council of Black Lawyers for many decades in its leadership. In addition, I was on the board of the American Civil Liberties Union, the largest of all of the civil rights legal organizations in the country. And I rose to the top in the small body called the Executive Committee that governs the ACLU. I would tell, and I speak quite a bit to K through 12 grades. I'm speaking coming up first week in December to a career day to a Montessori school in Prince George's County. And the first thing I tell them is to read books, hard books, to read books on tablet readers, but to read. And to read about multi-subjects that interest them. But if you're thinking about being a lawyer, to read books about the law and about biographies and autobiographies of famous lawyers, as told by them or told by anyone. But most of all, read and then write. The second thing I tell them is that education is the engine for social upward mobility. I think, like the civil rights movements, like Charles Hamilton Houston, like the NAACP in the 1930s and 40s, 50s, even up to the present, they always made a priority of seeking educational equality, because education, again, is the engine for upward social mobility. If you have an education, you are better prepared to exercise your other basic rights in voting, in seeking fair housing, certainly in employment opportunities. So I say that not only should they read, but reading is connected to education, and they should pursue the highest educational degree, certainly a college degree, in their lifetime. I've been around for 5 decades in the legal profession, starting in the 60s with the civil rights movement, continued through the 70s through the women's rights movements and other rights, throughout the 80s in broadening civil rights, certainly with rights for the disabled, eventually up to the 2000s with the LGBTQ, and more for elderly, for children, for families, certainly the right for a therapeutic abortion, and the rest. And we are certainly in a swing of the pendulum, particularly in the law, towards the right and towards the conservative. Clearly, with the election of Donald Trump as president in 2016, with the inauguration in 2017 of a pulling the rug off the cover and exposing white supremacy, from the Charlottesville, Virginia incident to hate incidents to mass shootings with shooters citing racist beliefs, with the war now against refugees seeking political asylum in this country. We have clearly swung towards conservative politics, conservative economic policies, conservative government support for its citizens. And as a student of history, and as a major in political science and philosophy, and as a reader of history, I'm currently reading the outstanding biography on Frederick Douglass. I find myself somewhat comfortable in understanding this period we're going through by some of the signs you mentioned. And I'm drawing upon the resistance that our forefathers and foremothers exerted ever since slavery, and the fight against abolition, and the continuing fight for the right to vote. And I am quite comfortable in continuing to resist oppression and to fight against these new waves of opposition to fundamental civil and human rights, both domestically and internationally. So people ask me often, well, how do I maintain my stamina, maintain my dedication to fighting for civil rights when, of course, you lose more than you win? And I say, from some of my intellectual history, such as Harriet Tubman, or such as Charles Hamilton Houston, as I mentioned, or particularly such as W.E.B. Du Bois. And my view is, I'm not in this to win, although I enjoy the victories that we achieve in civil rights, but I'm in this to resist. And I get my energy and my satisfaction that I resisted oppression, regardless of the outcome. I fought against it. I would conclude this interview with me with two of my favorite sayings. One is by a revolutionary leader in Africa who helped lead his people to liberation and to independence. And his name was Amilcar Cabral. And he said, "Tell no lies and claim no easy victories." And the other is the one I've mentioned repeatedly, Charles Hamilton Houston, the famous lawyer, graduate of Harvard Law School, brilliant scholar, made the law review at the time, far ahead of Barack Obama when he went to Harvard, and he was the editor-in-chief of the law review. But Charles Hamilton Houston said, a lawyer is either a social engineer or a parasite to society. I'm proud to be a social engineer. And as they say down south, I'm glad I came.